Hi, Austin divorce attorney Ben Carrasco here to talk to you about 12 things you should not do during your divorce case. Let's dive right in. Number one, posting about your spouse and your divorce on social media. Just like in the criminal context, in a divorce case, anything you say or do can and will be used against you at trial. So if you don't want to see something blown up as an exhibit that is shown to a judge or jury in a future hearing or at a future trial, don't say it and don't do it. Your posts on social media, the way you communicate with your spouse in text messages, the way you communicate about your spouse and your children to other people, third parties, all of that is discoverable evidence in your divorce. That means the other side can petition the court to order you to produce text messages, video recordings, and your social media post. And once a divorce is filed, you are not permitted to delete or eliminate or remove any of that evidence. You have a duty to preserve evidence once a divorce case is filed. And if you fail to do that, there can be consequences for you at trial. So again, don't say anything disparaging about your spouse in social media. It can have an impact on how the court ultimately determines who gets primary custody of your child. Why? Because it's important for the court to know that you support your child's relationship with the other parent. And judges, in my view, it is a cardinal sin in the eyes of most judges to alienate your child from the other parent, to not support your child's relationship with the other parent. And electronic evidence, whether it be text messages or social media, can often be indicative of whether you support the child's relationship with the other parent. And that's in addition to your own testimony and the testimony of your spouse. Number two, this dovetails with number one. Don't disparage your spouse in text messages. In fact, once a divorce is filed, I wouldn't even be communicating with anyone else about your divorce via text. If you want to vent or talk about your case with a family member or a friend, do it over the phone. Do it in person. Don't talk about it over text because, again, text messages is discoverable evidence, and you don't want those embarrassing texts to be used against you when you go to trial. Number three, don't spy on your spouse electronically. For example, don't install a device in your spouse's car that would record your spouse's conversations with third parties. This is illegal. Not only is it illegal, but the evidence that you may derive from that is likely not admissible in court. There can also be consequences for property division if you engage in this sort of behavior. So before you do anything like that, consult with your attorney. Any attorney worth his salt is going to discourage you from engaging in electronic eavesdropping. Again, divorce is hard enough as it is. You don't want to compound it with a criminal charge. Number four, if you are alleging adultery in your case, then don't engage in adultery yourself. Under Texas law, adultery is sexual intercourse with someone other than your spouse during the marriage. And even once a divorce is filed, even once you're quote unquote separated, you are still married to your spouse. I've had many cases where I represent a client who pleads adultery. We've got evidence showing that there was adultery. But before the divorce is finalized, my client mistakenly assumes that it's okay for them to date and start seeing other people. It isn't. Trials are about drawing clear and clean contrasts with your adversary. If I'm going to court, I want you to be wearing the white hat. And I want to put your spouse in a black hat. I want you to be the hero of the story, the victim of the story, and your spouse to be the villain. And the more you engage in conduct that mirrors the conduct that we're trying to use against your spouse, the less I'm able to make that contrast, the muddier the waters get, the more confused the evidence becomes, the less of a contrast I can create in front of a judge or jury. So if adultery is going to be a central theme in your case, it is imperative that you abstain, you take cold showers, you don't get on dating apps, you don't start seeing someone casually, you don't tell me, well, we went on a few dates, Ben, but we didn't actually have sex, so technically I still haven't committed adultery. I don't want you in a deposition having to answer uncomfortable questions about how many dates you went on with someone, and then you're on the defensive explaining, oh, we just went out a couple of times. We didn't do anything physical. Or, yes, I got on a dating app, but I didn't actually go on any dates with anyone. You need to refrain from all of that. Now, I will concede that certainly judges view adultery that committed during a time of separation, at least some judges view adultery committed during a period of separation differently than adultery that was committed before the divorce was filed. But why create the headache? Just listen to your lawyer. I don't want to have to be on the defensive when I'm going to court. I want to be able to show a clear and clean contrast with the other side. I don't want to have to be, if you're explaining in trial, you're losing. I don't want to have to explain your behavior. I want to put the other side on the defensive. I want to be able to go on the offense. And if you're engaging in the same behavior you're accusing them of, that complicates my job. So if you plead adultery, you need to abstain from seeing anyone until the divorce is finalized. Number 5, don't violate court orders. In most counties in Texas, we have what is called a standing order. I practice primarily in Travis, Williamson, and Hayes counties. All 3 of those counties have standing orders. These orders go into effect as soon as a divorce is filed. They're attached to the divorce petition, and they apply to both you and your spouse. And these are orders that essentially govern your conduct during the divorce, because a divorce can last months. Some divorces last years. So these orders essentially strive to maintain the status quo with respect to the kids and your assets. And they also have, there's also orders just governing your general conduct in terms of how you relate to your spouse. So for example, these standing orders will say that you cannot communicate with your spouse in an offensive manner. You cannot harass your spouse by making repeated phone calls. With respect to the children, they'll say you cannot secrete or hide the child from the other spouse. You cannot sell or dispose assets without your spouse's consent. You can't raid an account without conferring with your spouse. You can only spend money on reasonable and necessary living expenses and your attorney's fees. That means no extravagant trips or vacations. That means no big purchases unless you and your spouse agree. People see the temporary order, these standing orders, they're aware of it, but many clients don't read it carefully, and unfortunately, many clients don't follow these orders. And if both sides are doing it, I suppose, and it matters less when we get to court. But again, like I said earlier, winning a trial is about drawing contrast. And if I can show that you've been the good guy or the good woman because you follow court orders and your spouse doesn't, that's only going to help you when we get to trial. Raiding accounts, conveying assets to third parties, hiding money, all of that behavior can have an impact on how the community estate is ultimately divided. It can result in the non-offending spouse getting a disproportionate share of the estate. With respect to the children, hiding or removing the children or excluding the children from the other spouse, again, that can have an impact on how ultimate determinations of child custody are made when we get to court. Violating the conduct provisions, those go to whether or not you're a good co-parent. That kind of violating those provisions can result in your spouse getting either sole custody, meaning they're going to have the exclusive right to make important decisions on behalf of your child, or they're going to have the right to make those decisions after conferring with you and function as the tiebreaker. So it's very important that you comply with court orders in your case. I talked about the standing order, but if you have a temporary orders hearing and a judge issues temporary orders regarding the possession schedule, orders regarding how your household bills are going to be split, temporary visitation orders, you need to comply with those orders as well. This is a simple thing to do. For me, not complying with a court order is a fireable offense for a client. I expect my clients to comply with court order. It is the bare minimum that you need to do in your divorce case in order to be successful. Number 6, don't lie to your lawyer. Your lawyer is your advocate. Your lawyer is your champion. Your lawyer cannot be effective if he or she doesn't know the full truth about you, your life, your spouse, your case. During the consultation, it is imperative that you disclose to your lawyer the good, the bad, and the ugly about your marriage. It's difficult. You barely know this person, but know that your communications with your lawyer are sacred. They are confidential. I cannot disclose my communications with my client to any third party without my client's consent. And I can't give you good advice if I don't have all of the facts. It serves you no good to not share things with your attorney. So, again, tell your lawyer the truth. Be transparent. Number 7, I know this is hard, but to the extent that you can, don't make emotionally driven decisions. Divorce is hard. It's an emotional roller coaster. You feel like you're under siege. You have uncertainty and fear about the future. You have uncertainty and fear about your children's future. And under those circumstances, your judgment can be clouded. But the more that you can set your emotions aside, and particularly with respect to property issues, treat this as a business decision, the better off you'll be. Pick your battles. Don't fight over petty things. Don't fight over airline miles. Don't go to trial because you want to get another 1 or 2% of the community estate. You will recover from this process. You will have a new chapter and a new life after this process. You will get through it, but you'll get through it much better if you can make rational decisions and not be driven by your emotions. I try to counsel my clients to do that, but it's often best if you go to therapy. Talk to someone about your feelings. Talk to a professional. I'm a lawyer. I'm not a therapist. My clients often call on me to play that role, but that's not what I'm equipped to do. That's not what you're hiring me to do. You need to reach out to a professional who's trained and qualified to help you navigate the emotional challenges that you're going to face in this process so that you can get through it successfully. Number 8, don't discuss the litigation with the children. Obviously, divorce is going to bring significant changes to the lives of your children. And it's tempting to have conversations with them about it. And with older kids, they're going to be more demanding about what's going to happen. To the extent possible, I think you and your spouse should have those conversations with your children together. But you should not be enlisting your child as an ally in the divorce. You should not be making the child feel like he or she is a pawn in the divorce. You should not be putting the child in the middle. You shouldn't be using the child to communicate with the other parent. Those are all things that if it comes out in evidence, can influence how a judge is going to make ultimate custody determinations, who's going to get primary custody, what the possession schedule is going to be. And just like judges don't like seeing parents disparage each other, just like they want to see parents who can support the child's relationship with the other parent, they also don't want to see parents involving the kids in litigation. If you have an older child, a teenager, you can certainly file a motion to confer, and the judge can interview your child regarding their preferences, but you should not be prepping the child for that meeting. You should not be lobbying the child about what to say. You should consult with your attorney about how to broach conversations with your child about the process before you have that discussion, because you don't want the judge to get the sense that you're trying to manipulate your kids. Number 9, and this dovetails a little bit with number 8, and this is don't introduce your child to your paramour. If you are cheating on your spouse, if you have a new boyfriend or girlfriend, don't expose your child to that person. Judges in temporary orders hearings, they will often they will put morals clauses in the temporary order, which essentially say that you cannot have your child around a paramour until the divorce is finalized, or they may say that you cannot have any overnight. They'll say that if you're having a romantic relationship with someone, you can't have that person around your children from 6 p.m. to 8 a.m., for example. Very common to have those sorts of provisions in a temporary order. But you don't want to have to be ordered to do that. You want to have enough good sense and judgment to know that it is not a good idea to expose your kids to your affair partner. Again, this is behavior that can have an impact on ultimate custody determinations. Number 10, consider the financial and tax implications of your potential property division. If you go to trial or mediation, you will be expected to propose a division of assets to the court. Each side will submit a spreadsheet listing all the assets and their proposed division. So if you have a $2 million estate, for example, and you want a 50% division of the estate, you're going to propose that you get $1 million out of some combination of assets. Do you want it to be more on the real estate side, or do you want it to be more cash heavy? Those are conversations you should have with a financial planner. You may not want to have real estate. You may want to have more cash that's available to you. But on the other hand, if it's all in retirement accounts, then there could be tax implications for withdrawing from those accounts before retirement. Those are conversations you need to have with a tax professional. I'm a family lawyer. I'm not a tax professional. Notwithstanding that, my clients often ask me questions about taxes, like who gets to claim the kids. That one I can answer. But more complicated financial considerations, those are questions you should be asking well before we get to mediation, certainly well before we get to trial, so that you can make an informed proposal to the court about what combination of assets you want to seek as part of the division of the estate. Number 11, don't abscond with the child after you file for divorce. I understand that clients have concerns about how their spouse is going to react when they get served with divorce papers. It's understandable that you may be fearful about how they're going to react. But absconding with the kids, i.e. taking the kids, moving out of the house in the dead of night and going to some apartment, and then putting your spouse in the position of being at your mercy as to when they see the children, that is not a good look when you get in court. That is the kind of behavior that could actually result in your spouse getting primary custody of the child. If you have a safety concern, if your spouse has been physically or emotionally abusive to you or the child, then talk to your attorney about seeking a temporary restraining order or a protective order or some other temporary emergency relief until we can have a fuller temporary orders hearing in front of a judge. You can apply for emergency relief that is based on an affidavit outlining incidents of abuse or neglect. And if a judge signs a temporary restraining order, then that can result in the other spouse not having any contact with the child, at least on a temporary basis. But go through that process. Don't just take the kid and leave because you're fearful about what your spouse might do. Emergency relief is based on what people have actually done, not fears about how they're going to react if they get served with divorce papers. And finally, number 12. This one should be fairly obvious. Don't assault your spouse. I had a case where I was representing Dad, and it was fairly clear from the evidence leading up to the divorce filing that Mom had been the child's primary caregiver. Dad worked outside the home. Mom was the one who was mostly inside the home. She, if we had gone to trial, likely would have been the primary custodial parent given those facts. But they had a domestic argument, and she slugged him, hit him in the face, blood coming down his face. I believe she was arrested for assault, and it reversed what would have been a fairly predictable outcome. And Dad ended up getting primary custody of the child because family violence is a big factor. If there's evidence of family violence, that is generally disqualifies the offender from getting primary custody of the child. It can also have an effect on conservatorship. So you've got visitation and access, and you've got conservatorship, which are rights and duties like making the right to make educational decisions, the right to consent to invasive medical treatment, the right to consent to psychological, psychiatric, obviously the right to designate primary residence. That's the big one. And if there's family violence, the law actually says if there's a finding of family violence, it precludes the parents from being joint managing conservators, meaning it precludes them from exercising many of those rights by joint agreement, and requires the court to designate one parent sole managing conservatorship. If there's family violence, the court is not going to expect that those two parents can co-parent effectively and reach shared decisions. So again, don't slug your spouse, don't hit your spouse, walk away. if there's a conflict, especially for the men out there, because there is a double standard when it comes to domestic violence. And if you find yourself in a volatile situation, you need to just leave and cool off before you do something that you're going to regret. So I hope you found this helpful. These are just 12 things. There are others. If you meet with and we have a consultation, we can go over other things that you shouldn't do during your divorce. But these are the things that I thought of tonight. So thanks for listening.